Good afternoon, everyone. This is Jim Houlihan. I'm here with Bethany Centrone.
Good afternoon.
Welcome to the second of our 5 public sector webinars. Today we're going to be addressing social media in the public workplace. This program has been authorized for HRCI and SHRM credit, so you will be receiving information after the program confirming how to receive your credit. You'll also receive a copy of the slides that we're using for further reference. Thank you for being with us here this afternoon. Bethany and I decided to start these public sector webinars because we have a number of public sector clients who, for whatever reason, weren't able to get away to attend our annual workplace seminar or some of our breakfast briefings. And so rather than not serve them and provide this education, we decided to use the technology that's available and provide these webinars. So we're appreciative that you're here with us this afternoon, and we look forward to working through a very complex topic, social media. Before we start, I want to just ask you to put on your calendars the next 3 webinars that we've planned in January, February, and March. I think they'll be informative and address some of the concerns that are facing a variety of public sector clients. I would use this opportunity to suggest that if there are particular issues or topics that you think would be useful to present in a webinar or address in a webinar, please make a comment on the follow-up questionnaire that you'll receive so that we can factor that into our planning process. So this afternoon we're going to talk about social media. The slide that you're looking at now really is only a small representation of the types of programs and websites and operations that are out there that fall within the broad category of social media. I think it's mind-boggling to really see how social media has grown and developed and morphed over the last several years. There's a definition of social media, but really it encompasses so many things that I like to use the conversation prism that Brian Solis has developed with his partners. This conversation prism was first developed, I think, about a decade ago, just to try and capture the state of social media and organize it according to the important social networks that were being used by professionals and by everyday consumers. It was designed to provide a visual depiction in one space about the evolution and development of social media. As we were preparing for the broadcast this afternoon, one of our staff mentioned that this graph is already out of date since RDO has gone out of business, and I'm sure there are several other websites that are no longer functioning. In fact, in this updated version, Brian Solis mentioned that he had to remove 122 different services from the prior version and added only 113. So you can see that in terms of talking about social media, the breadth and depth of what that really means and how your employees might be using social media defies description. A research by the Pew Research Center indicated that in the period from 2012 to 2014, over 70% of the adult population was using Facebook. You can see that that's far and away the most used social media website, followed by LinkedIn and Pinterest, Twitter and Instagram. Of the people that are using Facebook, 70% of those users indicate that they're daily users. That's a significant amount of time if you think about it, and I think one of the things that we're going to talk about today is that I surmise that a lot of that daily usage is coming on working time and maybe interfering with the performance of their assigned duties. Certainly, that's something that we need to talk about and guard against. The current reality about social media, according to a recent study by the Proskauer Rose law firm, about 90% of employers use social media for some business purpose. More than 70% of employers have had to take disciplinary action against employees for misusing social media. And it's obviously a topic that's getting employers' attention because about 36% of employers actively block access on their corporate intranets and internets to social media sites. And then on the other hand, about 43% of employers allow employees to access social media sites at work. Interestingly, over 40% of employers monitor their employees' social media use at work. Clearly, that's something we're going to talk about later in the presentation. Once you start monitoring in the public sector, there are a variety of hoops that you have to jump through to make sure that you're not violating the Constitution or the various employment laws. One of the important things about that we want to talk about today is that by developing and enforcing a social media policy, you begin to shape your employees' reasonable expectations when it comes to the use and abuse of social media at work or during working time. Those policy considerations have to take into effect the constitutional protections that apply to public employees, but the fact that the Constitution provides additional protections for public sector employees doesn't mean that you shouldn't develop and enforce a social media policy. In fact, without a policy, your ability to lawfully address social media abuse is greatly diminished. Many of you are familiar with some of the legal constraints on your ability to promulgate social media policy or to address employee concerns in terms of social media abuse. Obviously, the laws prohibiting discrimination in employment, Title VII, the Age Discrimination in Employment Act, the Americans with Disabilities Act, and the New York Human Rights Law pose the same type of limitations on your ability to address social media issues as exist on your ability to make general workplace decisions. You have to make good decisions that are free from unlawful bias or unlawful retaliation. So those same factors have to be accounted for whenever you're dealing with social media issues. There are some other laws that come into focus, particularly when you're dealing with social media issues. The New York Correction Law, which addresses in what way you can lawfully consider an individual's prior conviction record with respect to employment matters, and probably a law that isn't often raised but has particular relevance in the social media context, and that's New York Labor Law, Section 201-D. That law prohibits discrimination against employees for engaging in certain recreational activities, which the statute defines as any lawful leisure time activity for which the employee receives no compensation and which is generally engaged in for recreational purposes, including but not limited to sport games, hobbies, exercise, reading, and the viewing of television, movies, and similar material. So you can see how someone's social networking activities, if they're engaged in their off-duty time, likely fall within the scope of recreational activities protected by Section 201-D. So that's something that as you begin to formulate a policy or decide whether to impose discipline or take some sort of corrective measure for an employee who's engaged in social media abuse, you have to definitely take that into account. We're also going to allude to briefly the impact of the Taylor Law and the federal laws concerning emails and stored communications. Those are obviously, for some public sector employees, the Taylor Law is going to affect how you go about promulgating and enforcing a social media policy if you've got collective bargaining relationships. The Stored Communications Privacy Act concerns the legal limitations imposed by federal law when you are accessing someone's stored electronic communications. Generally, if you require consent as part of the employment process and you advise employees that you're reserving the right to review and capture their email communications and other electronic communications, then you generally won't have problems in that arena. I'm going to pass the baton over to Bethany at this point in time. I think one of the key elements here is really thinking about and developing a customized social media policy for your particular governmental entity. What might work in a large county is not going to be the same type of policy that a small municipality needs or that perhaps the school district might need. So I'm going to turn it over to Bethany now. She's going to talk about considerations when you're drafting or revising your social media policies.
Thank you, Jim. And one of the things that's sort of represented in the grouping of the prior slide is that there's the things that you want to consider, that there are laws that that constrain your ability to take action based upon what you know, those anti-discrimination statutes, and you may learn lots of things about your employees that you wouldn't otherwise know when you're looking at social media use. So those are some areas that you want to be careful to consider, and also there are the laws that restrict what you can do with your social media policies directly. So what do you really want to consider when drafting your policy or adopting a policy? The first is that, what's your philosophy with social media? Some employers may want to ban it completely, but some employers, as was shown in the prior slides, use social media for productive purposes. So you may have your employees, if you're a municipality, you may reach out to your constituencies through social media. You may have Twitter sites and have your residents follow you. If you're a school district, teachers may use social media sites to connect with students on a more personal level, but professional, that those students are more used to communicating through. So how do you want to use social media in your organization is really the most important thing to think about when first drafting your policy. If you have if you have official or professional sites or use, then you want to make sure that your policy indicates how those are supposed to be used and what can and cannot be on those sites when somebody is talking officially as an employee of your organization. Also, you want to consider what other policies you currently have that may be relevant to social media use. I'm sure that most or all of you have anti-harassment policies. So if you have employees that are engaging in inappropriate behavior over social media, those policies might apply. You may have codes of ethics that would apply to your social media policies and other similar types of policies that you want to make sure that you either reference or at least consider when drafting your social media policy, so that you make sure that there aren't conflicts. And then again, you want to identify what you want your employees to have access to while at work. Do you have the capacity to limit access or use at work by blocking sites? Are there sites that you want to block and sites that you don't? So for example, if you don't want employees on Facebook because it's personal, that's more personal, but maybe you want them to be on LinkedIn because that's a professional site. Oops. When you develop your policy, the best thing is to be open with your employees and talk to them about what social media really means and explain why the policy is necessary. You also want to identify who this policy applies to. Do you have vendors or contractors, volunteers, interns that might be working through or for your organization that you want to make sure that are covered by your policy in the event that there's something occurs in the future that you need to address. This is difficult, but you want to try to anticipate and address new technologies in your policy. In other words, don't limit it to listing 5 different sites that you currently know are out there. You really want to make sure that it's broad enough so that if a new technology or new site comes into play, that someone can't say, well, you didn't list X new site as one of the prohibited sites, so now I can do whatever I want on that site. You want to specifically define what limits that you're going to place on employees, what's expected at work. Some employers do let employees access social media during work time as long as it's not interfering with their job duties. Some prohibit it completely. Are there going to be restrictions related to social media outside of work? There are a lot of concerns with regards to how employees are portraying the organization that they work for or other employees, and how that might be an out-of-work social media use. And how are you going to address the use of your technological resources? Are you supplying the smartphone or computer or internet access or any of those other types of access points that are required to use social media for your employees? And how are you going to want to limit that or expand on that for personal use or professional use of social media? And a well-drafted policy is key to imposing discipline if there's bad behavior on social media, especially in the context of public employment, where we as public employers are restricted somewhat from bringing discipline for certain activities that private employers might not have to worry about. We have our First Amendment rights or freedom of speech, which we'll talk about and define for you later on in this presentation. There are rights against unreasonable searches and seizures, which would include could include going into someone's computer or email if your policies are not drafted appropriately. Oops. Again, what you would like you should be addressing in your social media policies, in addition to what we just spoke about, it is important frequently to make sure that your employees, if they are going to be on social media, when can they identify themselves as an employee of your organization and when shouldn't they? And if they identify themselves as an employee of your organization, in the private context, frequently those employers will require employees to put a disclaimer, for example, on things that they say on social media so that they're not attributed to the employer themselves. So those may be some precautions that you might want employees to take. If they're going to use your name, your logo, photos, or other materials that belong to your organization, you should want to restrict that. Obviously, as a public entity, you can't prohibit an employee from talking about your organization because they're allowed to talk about and criticize government. But there are things that they might not be able to use, such as, again, photos, information about your constituencies, confidential information, vendors, students, other employees. You really want to make sure that there are clear guidelines about those types of discussions on social media. Another area where social media has made it more difficult for employees is professional sites like LinkedIn, where you can go on and you can give, forget what it's called, where you can give references for people that you used to work with or recommendations just by clicking the button. And usually employers should have a policy that says that recommendations only come from your HR department or a particular person in your organization. And when there's this sort of large amorphous social media site out there where anybody can say anything that they want about an employee that used to work for your organization, it becomes more difficult to control that. So you would want to make sure that your social media policies identify that if you are going on one of these sites and either recommending or not recommending a friend that was an employee of your organization, that is identified as a personal recommendation.
Yeah, Bethany, I think where you're referring to, I know on LinkedIn you can recommend people for certain types of skills, and we're very careful about that because as lawyers we have to be careful not to misrepresent what our actual skills are. I've had some well-intended clients recommend me for skills that I don't have, so I've had to kindly decline the recommendation, but I think it bears mentioning, as you did, that that's a form of endorsement or reference that that may violate a municipal policy that says only the director of human resources can provide reference information. So it's something to think about and factor into your policy development.
And you certainly want to make sure that your policy clearly identifies what the consequences are for its violation, just like any other policy that you might promulgate for your organization. And so another topic, not just about restricting your employees or monitoring your employees' social media use, but one of the things that you definitely want to think about is how do you want to use social media with regards to your employees, and a big part of that is using social media as part of your hiring process. I think I've heard commercials on the radio recently about services that clean up your Google searches because 70% of employers say that they'll run a Google search before they hire a person, which I don't know if that's true or not, but it's a commercial. But it's certainly something out there that's available for us to take a look at as employers to determine whether or not we think somebody would be a good hire. It's the positives of being able to look at a Google search or social media. Obviously, it's an important decision. You want the best information. You want complete information. Lots of people present well in an interview, but may not be as responsible as they seem when they're in front of you in a suit and a tie. It gives you insight into the applicant. It could help avoid a negligent hiring case that could be brought by other employees. Obviously, it's easier to avoid a bad hire than get rid of a bad hire, especially in the public sector where there may be short probationary periods in some cases. Sometimes it's easy to be good for a few months or up to or a year, but then after that you're kind of stuck with people at times. And failure to hire cases are frequently less common than termination lawsuits because most people don't know why you didn't call them or didn't hire them, but when you fire them, they know you personally at that point. So again, we touched on this before, but one of the negatives with regards to doing these types of searches before hiring is that you will potentially get lots of information that you're not supposed to consider when making a hiring decision. And that's always a risk. You may find out that somebody has a medical condition. You may find out that somebody is in another protected category. You may find out that they're a staunch union supporter and an activist that you might think could be an aggravating factor if you hire them, and those types of things that you're not supposed to consider. It's easy when you don't know them because you don't have to consider them, but once the cat's out of the bag, there's a possibility that somebody could make a claim. And not everything that you see on social media is necessarily accurate and complete, so you don't want to make decisions based upon bad information if you would otherwise have a good employee on your hands. And in any situation, we have that, in the pros and the cons, but there may be litigation related to making decisions based upon that information that you weren't supposed to know. So the first thing that you want to do when you're considering using social media or Google searches or any of that other internet searches as part of your hiring process is if you want to do them, obviously, and if so, for whom? Do you want to do that kind of background check for anyone from the custodian all the way up to the CEO, or are there only specific job categories or positions that you think warrant that type of extra look? You want to define that scope in advance so that it doesn't appear in the future that you're only you're only doing the search for a specific type of applicant, and that you could be open to a discrimination complaint in that type of situation. You don't want to access any site which you don't have access to automatically, and you don't want to falsify information or impersonate anyone to obtain access. And that really would include asking somebody that is friends. So, for example, I know Bob is friends with Judy on Facebook. Bob, can you log into your Facebook site so I can see what Judy's doing before we decide to hire her? You should, again, there's as part of the statutes that we'll talk about in a few minutes, there are prohibitions, and it's unlawful for you to impersonate or try to get into somebody's password-protected social media site or password-protected email that doesn't belong to you without permission from the person. Again, if you do decide to use social media, you want to make sure that the person who's searching the social media is not involved in the hiring decisions. And if you have that policy and procedure documented, that will help insulate you from the accusations that you made decisions based upon protected status or category and made the decision to not hire somebody for an unlawful reason. And that person's going to have to be discreet enough to only tell you the information that you would be allowed to know and need to know to make those hiring decisions. Again, you don't want to reveal that protected information to whoever is doing the hiring. You want to limit the scope of the social media searches, both for your own operational benefit, because you could be on there forever, but also to make sure that you don't learn more than you need to know. And you want to have a uniform policy for who you're searching, what positions you're searching for, and how those searches are going to be conducted. The other thing that you want to make sure is that if you have someone that is not an employee of your company conduct a search, that could be considered an investigative credit report under the Fair Credit Reporting Act. So if you're not doing it yourself as the potential employer, and they're having an outside company that's assisting you with a search, for example, do that search, you would have to potentially get consent from the applicant before you do that search.
Yeah, Bethany, one thing to think about in terms of using social media for hiring, make sure that your employment applications are broad enough and require an applicant to consent to investigating their background and credentials. If that's broad enough to include social media, that's one form of additional protection you might have. The other thing you might consider is making, delaying the social media investigation until after you've identified a group or a select group of potential candidates. Generally, we recommend that you don't run background checks. If you do run background checks, you don't run background checks on everybody. You wait till you identify viable candidates and then run the background check, using all the required disclosures under the Fair Credit Reporting Act. That does two things. It saves you money. You don't have to pay for all those background checks, but you might want to wait to run the social media investigation until that point in time as well. And I believe that several of the major credit reporting agencies will also do a social media background check as part of their investigation. So just two other details to think about if you're going to use social media in your hiring process.
Yeah. And the other thing that that you need to think about as you're developing a social media policy, if you have a unionized environment, which most public employers do, is that there are some obligations to bargain as it relates to social media policies. Any work rule that could result in disciplinary action can be considered a mandatory subject of bargaining. Also, restrictions on employees' off-duty conduct would be subject to mandatory bargaining for your unionized employees. However, as we discussed before, you should consider what your current work rules and policies are, because you may already have the things in place that you need for your work rules. For example, again, we talked about the harassment policy. You've already bargained a harassment policy. Just because you're now applying it to social media use doesn't mean that you need to renegotiate an entirely new policy. You may already have a policy that restricts conduct that's off-duty based upon the nature of the employee's work. For example, there's case law where a police department terminated an officer for operating a sexually explicit website with his wife, and his termination was upheld over First Amendment and other claims, but mostly because the police department had a work rule that said that officers could not engage in conduct that might discredit the force. So there are certainly or likely policies that you have in place or work rules that you have in place where you would just simply be applying them to the social media context if you don't already have a social media policy. So I'm going to send it back over to Jim.
Yeah, when we were putting the slides together, I found this information to be very interesting about bring your own device policies. Most of my experience in terms of working with employers about their employees' personal smartphones has been about how to keep them from bringing the devices to work or using them. And so it was very interesting to me to find that there are a number of employers and government agencies that are now going in the opposite direction. They're encouraging employees to give up their government-issued cell phones and use their own personal smartphones for government business. Of real interest to me was the fact that the White House had actually developed some guidelines and sample policies and best practices for various federal agencies about how to go about, encouraging or transitioning employees from government-issued smartphones to their own personal smartphones used for government business. There is, you'll see a reference to the website there. There's a number of different policies collected there. It's interesting to note that there has been some migration of federal agencies to this bring your own device policy, but a recent report by Forrester Research suggests that it's not been very popular, primarily because of concerns over data security and potential liability. So it's certainly something that you might consider. It's clear from the White House's materials that these initiatives were undertaken for budgetary reasons. They simply could not afford to replace the BlackBerry devices which they were using at great expense, and therefore we're looking for ways to continue to connect government workers to their work without having to lay out the additional financial costs. Now, obviously, there's other considerations whenever you allow a government employee to use a smartphone to conduct business. There's the potential hours worked issue. You have to be very careful about letting any hourly employee use their smartphone to work from home or off location, because they have to accurately record their working time, and that can be a challenge when the person's not reporting to a brick and mortar site. The other issue is the incentives related to the BYOD programs. From the White House materials, a number of employers have compensated employees for using their personal phones, and that can get troublesome and contentious as well. So just something to think about as part of your overall cost savings and social media strategy. We're not going to move from the policy consideration section of the presentation to addressing what happens when you have social media misbehavior. And as Bethany's alluded to several times, there are special considerations, namely the New York and United States Constitutions, that apply to public sector employers when you are considering disciplining a public sector employee for social media conduct. The First Amendment is the principal protection that you need to be aware of. The First Amendment protects your employees when they speak, which I think everybody assumes speak extends to social media posting and blogging and for other forms of communications. So the First Amendment protects speech on matters of public concern, provided the individual is speaking as a private individual, not in their official capacity. These cases are very interesting because the legal test used to decide when discipline is appropriate and when it's not involves a balancing test, which balances the public employer's need to promote the efficiency of public service against the employee's right to express his or her views. So whenever you have a balancing test in the law, the outcomes are highly unpredictable because whoever's doing the balancing can make a difference, and then each case, the factors that go on one side of the scale or the other obviously affect the balance. I think one of the first things that as public sector employers you need to be mindful of is that when employees speak pursuant to their official duties and in their official capacities, the First Amendment does not protect them. Okay? Now, you'd think that it would be easy to decide when someone's speaking in their official capacity or in their personal capacity, but that's very difficult, especially in the social media context where somebody is posting on their personal Facebook off-duty and in a way that doesn't necessarily draw attention to their official role or responsibilities.
Some examples pulling from, and these, you know, as Jim said, these are case by case, and I think some courts can rule one way and some courts might rule the other. But an example of a gray area where a public employee was identified as speaking in their official capacity when you wouldn't necessarily have expected it is a case involving a teacher who referred to her students as the devil's spawn and mentioned that after a recent drowning of a student that she wouldn't throw her kids a life jacket for $1 million. And as much as that doesn't seem like she's speaking in her official capacity, the hearing officer in that case held that because she was talking about her students, she was speaking as a teacher and the First Amendment didn't apply to her. Another hearing officer might rule differently, but in that case, her speech was considered not protected, first because she was speaking in her role as a public official.
Yeah, we've got some, there's many examples, but we've got references to a couple of these First Amendment cases. One involved the city of San Diego. San Diego police officer sold a pornographic video of himself on eBay, stripping out of a San Diego police officer uniform. And the court in that case found that that speech, meaning the video, was not protected by the First Amendment, not because it was pornographic, but because the video was a debased parody of the police officer performing indecent acts while he was in the San Diego police uniform, and it impugned the mission of the employer and the professionalism of its officers. So there are a number of factors that go into whether speech is protected. Someone can be speaking in their personal capacity, but because of the context, the speech itself might take away any protection. So here, the fact that it affected the mission of the San Diego Police Department was enough for the court to found that that what would otherwise be protected speech, even though it's pornographic, lost the protection. Another case involving a school district was very interesting. Involved a teacher who had a private blog in which she didn't identify herself. She was writing under a pseudonym, Natalie M. But she, like the other case Bethany referred to some of her students and how rude they were by referring them to as jerks, dunderheads, whiny, simpering grade grubbers with an unrealistic high perception of their own abilities, and a number of other comments that I'm sure no one would like to read about their children. She had been blogging on this private blog for a while until a local reporter discovered the blog and eventually turned the teacher into a celebrity. Her comments and her blog were reported on a number of major news channels, and the teacher actually appeared on several televised interviews. Obviously, the reason that this is a reported decision is that the school district ultimately terminated her, and the teacher sued, claiming that her termination violated the First Amendment. But the court in that case said that while the blog as a whole was dominated by personal matters, there were certain passages which touched upon broad issues of academic integrity and matters of political and social concern. So that while the court understood that perhaps this was a matter of public concern, the court ultimately decided that the speech did not merit protection under the balancing test because it found that the school district was within its rights to terminate because the teacher's conduct eroded the necessary trust and respect that its teachers should command. So again, just by way of example, the types of situations under which these issues can arise are many and varied, and the outcomes are equally varied as well.
So call your attorney.
One of the issues that you may have heard about, even though you're primarily working in the public sector, is in the private sector. The National Labor Relations Board has had a number of decisions in the last several years where it's found that social media postings by employees were protected under the National Labor Relations Act. To date, the Public Employment Relations Board hasn't decided any cases yet in that context, but it's almost certain that if confronted with that issue, the PERB will provide protection to speech that relates to union activity, collective negotiations, or disputes over contractual issues or items. And that protection is likely to extend to the new form of communication that we're talking about, social media. And you know, I certainly anticipate that within a reasonable amount of time we'll get some guidance from PERB in especially this context. The protection that's likely to attach to social media postings under the Taylor law is not going to be absolute. There's always a point in time when the individual's rights give way to the public good and the good of the employer. So generally, examining other forms of bad behavior under the PERB decisions, if the posting or social media behavior is very confrontational or in some way designed to disrupt and actually disrupts the employer's operations, even if it was protected in its inception, PERB is likely to find that the speech lost its protection under the Taylor law. I'm going to turn this over to Bethany. We've got about 10 or 15 minutes left in the presentation. She's going to talk about the Fourth Amendment restraints on discipline for social media use.
So we're switching gears here not to talk about what employees might be posting, but how we find out about what the employees are doing. We alluded to it previously that the Fourth Amendment protects against unreasonable searches and seizures, and again that includes looking at somebody's smartphone, looking at their email, looking at their social media sites potentially. So we want to make sure that if you find out information that you're not going to be prohibited from using that information, and also as we discussed in a little bit, that you're not looking for information in ways that can be considered unlawful as in its inception. So you have to think about, are your employees using their work computers or smartphones versus their own personal equipment and accounts? It's another thing to think about with regards to the bring your own device policies. You have less ability to go into an employee's personal device than you would to have something that have a policy that says that we own our work computers, we own our work provided smartphones and technology and iPads and everything else, and we have a right to look at them whenever we want, which is a general often used policy. An employee's personal device is quite different. And then areas that become grayer when employees may access their personal accounts through their work computer. So I may, not here of course, may go into my personal Hotmail to read my personal email through my work computer. My employer may have the ability to see that I've gone in there, and potentially some employers, there are programs that allow you to identify keystrokes, and you could even potentially get into my password. you would potentially be able to access my personal email account that I access through my work computer, because that data and information is still available on your systems. And we'll talk about why you don't want to do that, but that is, there's a gray area, and there's some temptation, I think, at times to look into those areas when you believe that someone has done something especially egregious. Sorry. Oops. Sorry, having some technical difficulties here. All right. So just like with First Amendment protections, Fourth Amendment protections don't always apply. So an employee's right to against unreasonable searches and seizures will only apply if they have an objectively reasonable expectation of privacy in the place that's being searched or the item that's being seized. And that's based upon a societal expectation in most cases, but this is where your policies really come into play. If you have policies, and this doesn't just apply to electronic searches, but for your office, desks and lockers and other places within your organizations, and your work computers and your work cell phones and your work email, if you have a policy that says this belongs to us, we have the right to go into those anytime we want, and we can look at anything that's in there, then your employees will not have a reasonable expectation of privacy in those areas. And again, there's another reasonableness test and the balance with the legitimate need for supervision, control, and efficient operations when you are dealing with an employee as an employer and looking and investigating issues that might happen at the workplace, or not just even misconduct investigations, but you may need to go into an employee's office or computer to look for a file or a document that when the employee is not there, and find other things. And those challenges have been made when looking through employees' work-related things. So even if there is a reasonable expectation of privacy, we have this additional allowable searches if the search is reasonable under all circumstances, which means it was justified at its inception. Again, you had a legitimate business reason for going into whatever the searched item is. You expected that there was misconduct. You had a reasonable basis to believe that there was misconduct and that there would be evidence of that misconduct found where you were looking, or you needed a file or a document that happened to be, that you believed would be in the employee's office or computer. And then the scope of the search, in other words, what you are searching, is related to what you think you're going to find. So if you think that if you're looking for a Buick, you can't look in, you're not going to be looking in the employee's smartphone. But if you're looking for notes or, evidence of inappropriate texting, then obviously you would be able to look at the employee's work-related work smartphone. And this is an example of reasonable searches. So Domain versus Samuels is a case in which a police department was investigating abuses of overtime and learned that a officer was keeping notes related to his coworkers and what they were doing, and believed that that would provide evidence related to employees that might be reporting misreporting overtime work. So the employer searched the officer's desk, car, and day planner, and where they found the day planner in the desk, and the court had ruled that there wasn't an expectation of privacy in the desk or car, and there was in the day planner. However, the search was not considered to be unlawful because it was reasonable at its inception. They had information that there were notes that would lead to evidence of misconduct, and it was reasonable for them to expect that the notes would be in the police officer's day planner. So even though there was that expectation that the officer had in the day planner of privacy, the employer was was able to go into and look into that to get the evidence of misconduct as an employer. Again, this is different for those of you with police forces. It's obviously different than what the standard would be if a police force was investigating a private citizen. There you need probable cause and potentially warrants and different things to be able to conduct the search.
The next case as an example we have is an interesting one involving a public school district. The director of technology at the school district, a man named Cleary, was creating a PowerPoint presentation on the perils of social media, ironically. It was a presentation that he was preparing for students, and in the process of preparing it, somehow he thought it would be a good idea to take a photograph of a current high school senior, Ms. Cheney, in a bikini, which the director of technology found on Facebook without obtaining the students' or parents' consent to use the photograph. The student sued, claiming that when viewed in conjunction with previous slides, the presentation portrayed her as a sexually promiscuous abuser of alcohol, and that was the basis for her action against the school district. One of her claims involved a Fourth Amendment claim that that the search that the director of technology performed to get her bikini photograph was unlawful. The student claimed that her Facebook privacy settings were such that her profile could only be viewed by her friends and friends of her friends, and she argued that she was not friends with Cleary. So in that context, even though the director of technology technically did not have access to her Facebook account given her privacy settings, the court was just simply unwilling to attach privacy protections to the student's Facebook account, finding that that society would not be willing to recognize a reasonable expectation of privacy in her Facebook account. Now this is, I think there's other cases that view things differently, but this is an example of the types of problems you can run into if you're just, without really thinking, accessing someone's Facebook page and using material from that Facebook page for some business-related purpose.
And you know, there are other protections against unauthorized access to social media, Facebook pages, other areas where there might be password protected electronic storage, and we alluded to these earlier. And these are the Electronic Communications Privacy Act, the Stored Communications Act, and the New York Penal Law, Section 250, clearly making it a crime to go into somebody's accounts without permission and without authorization. So the Electronic Communications Privacy Act prohibits intentional or unauthorized interception and access of wire, oral, or electronic communications, and this would include email, texts, those types of things. So you don't want to, you know, tap your employees' personal accounts. Again, if you have a policy that says we own your work email, it's our system, or we own your work smartphone or cell phone that we've provided to you, it's ours, then there's implied consent to intercept those communications, and it's yours, so you've obviously consented to it. So you want to have those policies. Penal law, Section 250, it's the wiretapping law. It also prohibits monitoring and intercepting, accessing electronic communications without consent. Those policies create implied consent, and they help protect you. The Privacy Stored Communications Act prohibits intentional unauthorized access of wire or electronic communications while in electronic storage. Again, emails, texts, posts on social media would all be considered in electronic storage. Obviously, if you're an internet service provider, those don't apply. But where these things come into play, again, is you may find out from another employee or a resident or a student that somebody is posting things on their Facebook site that is inappropriate, or on a password-protected blog that's inappropriate, and you'll have a great idea to pretend to be somebody else and friend the person on Facebook, or try to otherwise get into the password-protected site, and doing that is unlawful. Again, I think also, inquiring minds might disagree, but asking an employee who is a friend of someone that you want access to their Facebook page or other similar site, I think also could want to follow these statutes if you're not also already authorized to be looking in there. That doesn't mean that if an employee comes to you and says, I just printed this out from my Facebook page because I saw it, and hands it to you, that you can't use that as evidence or you can't look at that. But what we're talking about is saying, Joe, can you log into your Facebook page so I can read what Sally had to say about me yesterday on her page?
Yeah, Bethany, the courts have generally not criticized employers who passively receive information from an employee or another person who gain that information lawfully or unlawfully. I mean, if it's brought to your attention and there's no wrongdoing in terms of your part, in terms of accessing it, the courts generally have not criticized or found liability for employers in that context.
And certainly you can, if you can go onto Facebook and go onto somebody's profile and they haven't set their privacy settings to preclude you from seeing what's there, look and use all you want. These statutes prohibit you from gaining access through fraud or impersonation. They don't prohibit you from gaining access in a way that anybody else could access it.
Bethany, don't you mean look and use all you want, subject to all the other warnings that we've given people in the last hour?
True, true, true.
And that brings us to the end of our program. I know we covered a lot of materials here, and we look forward to continuing to serve you.